I don't know. After hearing him calm and talking about the tether story, it's probable.
Just go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
Probation. What's going on? This is Colin. How's everyone doing? Happy Friday. Happy Veterans Day, Part 2. Hope everyone's doing well. This is a rather serious case. Mental health is no joke. As my friend KCC would say, take your meds. There's no shame in it. Take them. If you need them, take them. Let's go. Let's go. But before I hit the play button, you already know what to do. Like and subscribe, and do your jump kick back clips if you'd like to. All right, on to the voices.
And let's see. This is the matter of Brown versus Brown. Before I address that, the matter of Curtis versus Adams was also scheduled for 10:30. No one has appeared on that matter. Well, I guess it was scheduled for a review hearing. I can only assume that things must be going smoothly. So I won't take any action on that file. Okay, and Brown versus Brown. Give me a moment to review the summary that I got from the referee. I did look at it yesterday, but I need to have my memory refreshed. Okay, so Ms. Brown has filed a motion seeking to suspend Mr. Brown's parenting time because of his drug and other concerning behaviors. Mr. Brown denies the behaviors he's been accused of. Obviously, with the exception of a incident for which he was placed on probation by Judge Jordan recently. And I'm assuming, Mr. Brown, you oppose having your parenting time suspended.
Correct.
When I have disputed facts, I don't have any choice but to conduct an evidentiary hearing, but the behaviors are concerning. So I want to at least address what is currently happening. So let me just ask you, Ms. Brown, when's the last time Mr. Brown actually had parenting time with Addison and Amelia?
It was sometime in early September.
So your allegations include both drug use, which appears at least currently being monitored by virtue of his probation, where he's being regularly tested. So I would assume the drug use alone, given the fact that he's being monitored and tested, is less a concern. The other behaviors you complained about were some mental health related issues.
Yes, he is having hallucinations and hearing things, which has become my bigger priority of concern with my daughters as to what he hears. He called the police on us at 3 o'clock in the morning, a couple days before Christmas, and told them that I killed everybody in the house. So they did a welfare check at 3 o'clock in the morning. So what is he seeing in regards to my children? I know that the referee asked him if he hears things or sees things, and he said no. But when he broke the restraining order and we were in front of you for the PPO violation, he pled guilty. And I remember one of the questions you asked him was, did anybody tell you to say this or anybody promise you anything? And his question to you was, do you mean the voices in my head? So he's lying that he's not hearing voices, because he is. He said that he has never been diagnosed with a mental health history or diagnosis, and he isn't on meds. So it concerns me. His mom said that he can handle them pretty well by himself, but if they are in reference to anything that do with my daughters, then he gets really upset. So I don't know what he would do if he had my children. I mean, and the voices told him to do something to them or take them somewhere. I just don't know how safe that would be. So that is pretty much my biggest concern.
There was a period of time when he was getting parenting time supervised by his mother.
Yes. That was how it was before.
Is that something that you would be comfortable with?
Well, my concern is I don't know what he would do. Like I said, if the voice tells him in his head to, take the girls in the car and drive off, his mom's not going to be able to stop him. I don't know. That is my biggest concern. Like, what are the voices going to tell him to do? What is he seeing? I mean, if you're calling the police saying that I killed them, he's done it to his parents too, where he's seen that his parents are hanging from the ceiling dead, and he went down to the neighbors and called the police then too. How is somebody going to manage that? They're going to make sure my kids are okay in that. You're not on medicine, you're not on therapy, you're denying that these are happening now, even though when you were in jail recently, you came out of jail with medicine. Then you tell the referee you've never heard voices and you've never been diagnosed. My concern is it's going to fall through the cracks, and my girls are going to be the ones that get what if he tells them to kill my kids? Like, I would never be able to live with that, knowing that I am not trying to do everything I can right now to keep my kids safe.
So, Ms. Brown, what do you know about whatever medication it was that he was taking in the past?
I know that he got put in jail for the felonies that he had, and that when he got out, his mom told me that he was on medicine. However, when he got out, he tried looking for a doctor and nobody would prescribe him the medicine again. And as she just kept telling me that he's still not on the medicine. He's still not on any medicine. And from what he told the referee 2 weeks ago, doesn't sound to me like he has any intention of getting back on the medicine. I think they told me it was like for bipolar and schizophrenia. But again, that's just through his mom. Every time I asked, what was he diagnosed with? Is this something that isn't because of the drugs? It is more of a historical thing that I need to worry about hereditarily giving down to my daughters. Nobody can give me an answer, because I don't think he has really been diagnosed with something by a legal professional.
So, how old are your daughters?
11 and 7.
And I see you've been divorced for a few years now, but obviously you were together for a while.
Yes, we've been together for a really long time.
Did you see the behaviors when you were together?
No. We divorced because of drug issues, and I didn't see any of those issues then. And he was doing really good. Before September, he had the girls often because he was on probation again. He went through rehab, got clean, was doing really good. He spent a lot of time with the girls, more than what his parenting time allowed for or gave him. He had a ton. He had a great relationship with the girls. But it wasn't until he started seeing things and doing these things that it put my daughters in jeopardy. And his mother, who was supervised at the time, also agreed that the girls should not be around him right now. And I wholeheartedly feel that if that was the case back in September and nothing has changed since then, why is it okay to now put him in just because it's been a long time? I mean, there's a letter from Addie's therapist that I submitted to Corey and I sent to your assistant or secretary that also says the same thing. Like Corey had been an active person in their life. And I'm never the parent that wants to take them from that, but I need to know my kids are going to be safe. And that's why I'm not canceling parenting. I'm just suspending it until Corey gets the help he needs that ensures my children are going to be safe.
So, Mr. Brown, is it your position that Liz is just making all this stuff up?
I be honest with you, I don't know where she gets this from and where my mom gets this stuff from, but it's not true.
There are police reports. I mean, and there also was the time that like he violated the PPO in front of you. He asked, you know, do the voices count as people telling him what to do?
I put no contest.
So, Mr. Brown, have you ever had a psychological assessment?
No.
From what Ms. Brown is telling me, that when you're in a good state of mind, she wants the girls to see you. That there was a period of time when you were doing really well, and she gave you even more time than she was required to. It sounds like she really does want you in her daughter's lives, but she wants to know that you're safe. When I hear that from a mom, it really gives me actually great confidence that I can believe her when she says, this has got to be addressed. I'm worried that when I've seen these things, particularly the thing that happened around Christmas time, that's pretty scary stuff to a mother. Do you deny that even happened?
Yeah, let's get real here. Let's technically say I do see this stuff or hear this stuff. That's gonna make me, unfit to be able to be around my daughters. I mean,
not necessarily,
you get where I'm
sir.
coming from. I mean, okay, if I hear voices, big whoop-de-doo. People hear. If you look up the facts of life of how people hear voices and the reasons why they hear voices, people don't just act out, because of voices. You know what I mean? It doesn't put their kids at risk. It's actually a normal human thing if you actually look it up and do a little research. So I mean, if she wants to throw shade at me about hearing stuff and seeing stuff about kids not being safe, that is totally untrue. She's all basing this stuff off from what she hears from my mom, and she's bringing in a third party, which doesn't even need to be in between us. And I can't even contact my ex-wife, Elizabeth, because of the PPO order, so there's like no communication. So there's a huge, big, there's a link between our communications of two co-parents. We can't communicate with each other, so there's this big gap of information and communication between people. That's why we're in the predicament we're in, because we're trying to have a mediator of my mom, which would be the last person in the world who we should be having to go in between us as far as what's going on, what's not going on, to be, having information and, that kind of stuff between, two co-parents, it doesn't work.
All right. I'm not going to interject too much during this because I can't really say a lot to what he's saying. All you really need to know is the look on the mom's face. I don't need to say anything. Just watch her reaction every time he talks.
let me stop you for just a minute. So, Ms. Brown, tell me again what it was that he did back around the Christmas holiday.
He called the police, telling them that I had killed the girls and they needed to go do a welfare check on us. So it was either 2 or 3 in the morning, 3 police officers were standing in my daughter's bedrooms as they woke up because they needed to verify that my kids were awake.
Mr. Brown, how do you explain that kind of behavior?
I was just concerned about my kids' welfare because she wouldn't let me see them, wouldn't let me talk to them, and I just had a overwhelming feeling that there was something wrong with them. I mean, when your kids are yanked from you, like, you know, where you can't see them, you can't talk to them, and you can't even talk to the mom to figure out what the heck's going on. You know what I mean? Like, I just felt that there was something wrong. Felt like someone needed to go over there and check. My parents wouldn't communicate with me. She wouldn't communicate with me. I couldn't see him physically. So I did what any father would do. You know, I just felt that there was something wrong. I mean, it's a father's intuition. I mean, you can't just sit there and say it's a voice thing or I'm hearing stuff or seeing this, that. I mean, it was a gut feeling that there was something wrong. I mean, is that against the law? Is that against the rules that a father wants to know that his kids are being okay, that they're really safe and they're okay? I mean, imagine having your kids ripped from you where you can't see them or you can't talk to them all of a sudden and you don't, you know what I mean? You can't communicate with their mom. I mean, it's like they disappear.
Hold on. It is not a normal thing to call the police at 2 o'clock in the morning asking them to go to your children's home to do a welfare check just because you got a feeling something might be wrong. That's not normal at all.
Intuition, sorry to tell you. When you have your kids yanked from you and been through what I've been through with them being yanked and no communication, yeah, you know, it's pretty scary stuff.
The girls were not yanked from him. He again
Yes,
started
they
using
were.
the girls. He started using meth and started having the hallucinations in September. Visitations had stopped then. However, the girls and I still went over to their house. We still went over on Halloween, which was in October, to show them the costumes and get candy from them. I still tried to keep them, but the more I saw that things were going crazy when he would start showing up to my house and then accuse my neighbor of sexually assaulting his daughter and all of those things, it showed me that our lives were a little bit more in jeopardy and the damage she was doing to my daughters became more severe. And that's when I got the restraining order.
So let me ask Ms. Brown. I understand Mr. Brown's frustration not being able to see his children. And I understand from what you've already told me that if he were in a good place, you wouldn't have any problem with it at all. You encourage it. So I'm wondering until we can get to a point where you and I feel that Mr. Corey Brown is back in a good place, can we at least put something in place so that he can see his girls?
Can we do like a Zoom conference?
Well, that's exactly what I was going to suggest. I realize that I don't have the PPO file in front of me, so I don't know exactly what it says, but I can certainly modify the PPO to allow him to participate in Zoom conferences. So at least he has some contact with his daughters. I think as long as he's behaving himself during those conferences, which you would have complete control over, if he starts, saying things that are irrational or even scary to the kids, you can terminate the call.
Okay.
But assuming he's interacting properly, I'm assuming the girls would like to see their dad at least.
I know my oldest.
Like to...
I can tell you, my oldest. She really right now voices to me that she does not want to until dad is healthy. My youngest one, she does. My youngest one misses him, and I know my oldest one misses him too. She's just very scared. So I'm more than willing. We did a Zoom for our youngest one's birthday back in April with him as well. So I am fine with Zooms. That would makes me feel great. Like I feel like that would be a really good start.
So, Mr. Brown, I noticed from whatever I think was in the summary that you are not currently employed by an employer, correct?
No, which I don't know why that's even being brought up, but correct.
Well, it's because I'm trying to figure out what kind of resources you've got, and that will determine what I might end up ordering. If you had health insurance, it might cover something that I would order. If you don't have health insurance, paying for it out of pocket is going to be a pretty steep challenge. That's why I'm asking.
I have Medicaid.
You have what?
I have Medicaid.
You have Medicaid?
I have insurance. Yes, I have insurance.
Well, I'm not sure they would pay for what I'm thinking about ordering. Sir, it's whether it's a danger to your children or not, you understand that hearing voices is not normal. That if you're hearing voices, there's something going on that probably should be explored by a mental health professional. I'm not asking you to admit that. Have you ever had any interaction with Lifeways?
Yep, been down there numerous times, and they don't seem to. They don't have a concern with it. I don't get nowhere with them, so it's just a dead end. Been down there numerous times, against my will and voluntarily.
And they've never recommended that you talk to a therapist or that you talk to a physician and get medication to help address whatever issues it is they think you're experiencing?
Nope, not once. I've been down there a handful of times.
When's the last time you were down there?
I mean, just to appease my mother and my ex-wife, because they all think to be medical experts and I need to be on medication, because the medication doesn't do jack. Oh, excuse me. The medication does not do anything for me. When I was in jail, they put me on some psychotic medications, and it didn't. I still hear voices. I mean, big deal. It's normal for some people. It doesn't put my kids at harm. It doesn't. I mean, it is what it is. Medications don't do anything.
Here's what I'm going to do. Since you've got Medicaid, I am going to order that you have regular video conferences with your daughters so you can start seeing them again and talking to them. I'm going to let Ms. Brown regulate that. You absolutely can't be abusive or threatening to her during those Zoom conferences, because obviously she's the one that's going to have to moderate them to make sure they happen. I'm also going to order that you be evaluated at Lifeways to determine whether or not they believe that you are a danger to yourself or others, and particularly to your children, and that they submit a report to me so that I can see that.
Okay.
I think Ms. Brown has told me enough today that I've got a level of concern that I just want to make sure that I don't put your daughters in any kind of danger. I realize you say it's normal to hear voices. I'm telling you, sir, it's not normal. Whether or not it's dangerous is really the question before me. And I think the best way to evaluate that is to have a mental health professional evaluate you. So that's what I'm going to do. Pardon?
So that's the thing. I've never put my kids at harm, my ex-wife at harm, my parents at harm. I mean, this is all just over, me, when you have your kids ripped away and you can't communicate with anybody, you know, automatically your mind starts thinking the worst. You get what I'm saying? Like, it's almost like your kid's been
All right.
kidnapped from you. And you get what I'm saying? Like, you see how the correlation here? It's not, you know, I
hear
haven't
you,
ever
sir.
put her at harm or kids at harm. I've never acted out in front of them. Nothing that would ever cause any mental distress or concern for their safety. I mean, that's what I don't understand. Like, I mean, what's video conferencing going to do? Like, kids are supposed to be with their father. It's called interaction. I mean, it's almost like they're putting me on an island and not, you know what I mean, not giving me my rights.
Mr. Brown, it is not my intention that the only time you're ever going to see your kids again is on a video conference. That is not my intention. The reason I say video conference is it's something that can happen immediately, and I feel comfortable until I can get some verification from a mental health professional, as opposed to a layperson who's just afraid for her children. So that's what I'm going to order.
All right.
I'll put it. The order will be specific. I'll also make sure that there's modifications to the PPO so that you don't get in any kind of trouble for doing this. And we'll get that order out to both of you. Mom, let's see. Mr. Brown, are you still living at the South Harrington address in Parma?
Yes.
Okay. All right. I'll try to get something out as quickly as I can. You don't, Ms. Brown, you don't have to wait until you see an order to do a video conference if you feel comfortable. I would, but I'll make sure we get an order in place so that we know what the boundaries are, and let's move forward. Let's see if we can fix this. That's my objective.
Sounds good. Thank you.
Okay. Thank you both.
Yeah, so that happened. That actually happened. Hearing voices is normal. It took the judge to tell him it's not normal for him to stop saying it was normal. All right, let's move on. Let's move on to a slightly more humorous clip. How about that? All right, let's go.
Well, Mr. Slitter, did you hear me, Mr. Slitter?
Yeah, you can proceed.
Are you okay with that? Would you? I mean, with that, I would defer to you. Would you rather postpone it and be seen on video, or do you want to go ahead with it right now?
We can go ahead right now.
Any objection to that, Mr. Harrison? Mr. Wiggins?
No, Your Honor.
All right. The court will accept a waiver today and allow Mr. Sluter to appear via Zoom on just audio. Again, we have counsel, Mr. Wiggins on behalf of the people, and Mr. Gary David Strauss on behalf of the defendant, who joins us today via Zoom. We are here today for the defendant / appellant's motion for a bond while pending an appeal. Mr. Wiggins, I did receive the motion. I just want to make sure, did you file a written response?
I did not, Your Honor.
All right, thank you. Mr. Strauss, the floor is yours, sir.
Well, Your Honor, I'm sure you've read the brief. I think it's pretty complete. Just that I've spoken to Mr. Sluter's father, so he could stay with him. And we went through all the Giacalone factors, and I'm sure you're aware of, obviously, of our brief. I don't have a lot more to add. Not a danger to the community. It's a non-assaultive crime, as is required, and we have a good issue on appeal. And I didn't see any.
What's your basis for the appeal? You didn't have anything in your brief to suggest it had any legal support necessarily, other than, there was nothing in there that I saw that argued that it presented anything about the appellate issue.
Okay. Basically, Your Honor, it's to present the duress defense. Your Honor made the determination before he testified or before there was any offer of proof or anything, knowing what he might testify to, and the court focused mainly on what happened at that moment in time. But I believe that's a very strong issue, because without hearing what he had to say, to be under duress, I could give an example. It may not be the best example, but if somebody called me and threatened me, I'm going to take out your family in 2 weeks, and I start seeing cars or whatever, and it's protracted, there's a 2 week, 2 weeks in the interim, I think I could be under duress. I mean, it's for the jury to decide, but obviously I could be under duress with that kind of situation. It doesn't have to be immediate, like somebody has to draw a gun on me. So that's basically the issue. I believe it's a very strong issue. Yeah.
I don't buy your appellate issue, even in the slightest. There was nothing presented either by any offer from the defense that there was any threat to kill him or hurt him. There was the officer, if I recall correctly, never even got out of the car. Just took off and fled. No, I'm talking. He just took off. No, it's all right. He just took off and fled. If I remember right, reaching speeds at 100 miles an hour, having cars having to dodge him on routes, which of course plays against your Giacolone argument that he's not a risk to society, or that he will be responsive to anybody trying to apprehend him later on in the future. The evidence from that trial was 100% clear. Your client will put other people in danger to avoid being apprehended. So that definitely does not support your argument for the granting of bond. That case was clear. Your client led multiple agencies, multiple police officers on an extremely high-speed, dangerous chase. There is absolutely no way for this court to ever believe that this client is not a danger to other people. So there goes that argument, and there goes your other argument as to having a good appellate issue. There was nothing presented that he was underneath any duress. Nobody there made any threats to him. Nobody there he didn't even know who was in the car. Mr. Wiggins, do you have anything to argue?
No, Your Honor, the court stole my thunder.
Thank you. Anything else, Mr. Strauss?
Yes, well, obviously, Your Honor, we disagree with that. If the police were stopping him, there was really no reason, as you know, that they were, which seems strange to me, at least from my perspective, that there was a notice to appear, I think, with 3 weeks out. On the exact dates here, but the court's aware of that. 3 weeks out, I think the warrant was for the CSE charge, which was denied with prejudice. I mean, no process, with prejudice, and the whole situation. I don't think there was nothing on the record that I saw that he would not have appeared when the notice to appear came for that case. And on top of that, in his mind, he did nothing wrong to invite a warrant. I mean, the notice to appear, there's no evidence that he wouldn't show up at all. And again, I would say that in the case, probably late on this, I would just submit my appellate brief to you, Your Honor. But I think the basis is there. Where he has to have an opportunity. The case is, I don't know if you want to take it under advisement. I mean, we're not high appellate briefs of public record.
No, I'm not taking under advisement. Wasn't there an arrest warrant for him?
There was. The arrest warrant was signed that morning. They had him under surveillance waiting for the warrant to be signed. The warrant was signed by Judge, I believe it was Judge Vinalt, not a magistrate, and then right away, MSP got the word and they tried to do the traffic stop.
And did that. So what is Mr. Strauss, what are you talking about? There was a notice to appear that he may not appear for. What was that about? I understand.
Well, there was a notice to appear. Okay, I'm sorry. That'd be a record in your court. He had notice to appear, and then also for a preliminary exam, which was about 3 weeks after the police have showed up with the warrant. But again,
I'm lost because they were arresting him on a lawfully issued warrant by another judge.
Your Honor, I'm not sure if, I'll be honest, I don't know if he had another case pending at the time.
He's had 3 cases pending at the time.
The, I don't know if council's talking about when they're arraigned, they receive a notice to appear for PCC and the prelim.
Right.
Which would be about that same time period he's talking about.
On the other file, but he also had the new CSC warrant, I think was the one that was issued that day.
Correct.
Yeah.
All right, so the police officers lawfully try to take him under arrest. He decided not to give in. He had, I think this is the one where there was a stop on Business 131 up on Mac Trail, or what's Old Mac Trail.
Correct. The officer attempted to get out of his vehicle. As soon as the door opened, Mr. Sluter took off.
And then they turned right onto M42.
Correct.
Heading toward Expressway 131. And then did he stop?
That's
Because there was a collision with the car.
correct.
Yeah. Yeah, but I can't remember did he stop?
There was not a stop. He continued through the officer's vehicle, got on
Yeah.
the expressway.
On the expressway and then led all the way down from Manton into Cadillac on Boone Road. Got off on Boone, well, first of course, he crossed the median on the expressway and then went up the on-ramp in the wrong direction, pushing cars off to the side, right?
Cars did leave the road.
Yeah, and then turned east, ran to the end of Boone Road to where it comes to a T with Sealy Road, and then drove on a 2-track. And then kept running because he basically was probably on his way to his dad's house.
That was the theory.
Yeah, that was the theory.
And the dog apprehended.
Yeah. Number one, I don't think the appellate has a legitimate appellate argument. He didn't have any duress. He didn't even know what was in the car. Next, the court does not find that the defendant is likely to appear because if he's likely to, he fled police. If he doesn't want to show up, he's not going to show up. The court hereby finds that there is no factual support for the argument, and the court denies the request for bond, and the court will leave the defendant where he's at. Mr. Strauss, if you could please draft an order to that effect. Just say for reasons stated on the record today, the court denies the motion. Anything further, Mr. Strauss?
Yes, we'd like to order the transcript.
I don't order your transcript. You call my clerk and order it. I don't do that. Go ahead and
yeah,
order it.
right. I'm right. I'm announcing that. No, I didn't think, Your Honor. Yes. No, I didn't think you would personally do that. Okay.
No,
I'll
well,
go
then
ahead and
you
order
call
that.
the clerk. Yeah, good job. Thank you. We're adjourned.
You got a good job from the judge. Good job. Yeah. Again, I feel like I don't really even have to say much on any of these cases. They're just, that last one was wild. I said it was humorous. It's not humorous. It's kind of, yeah, you know what? Let's just play the last clip. Let's just watch someone go to jail. All right. Spoiler alert.
Mr. Lusk, if I can have you state your name and date of birth, please.
Vernon Scott Lusk, 10/18/1967.
All right, we have before us a motion in order to show cause for revocation of deferred prosecution. Suppose what I'll do, I did sign off on that today, is first of all, ask Mr. Johnson how you're planning on proceeding today.
Your Honor, I would ask that we set the hearing over. The sort of, I think, primary bases for this revocation are new law violations as well as a new pending DUI matter. My request would be to see a resolution of those matters prior to taking action on the revocation question. So he has 2 matters pending. One of them is pending DUI. And then another is an assault 4 out of Clark County. I represent Mr. Lusk in the assault 4 matter. That case is set for trial on February 23rd. So we do think that is an appropriate timeline for resolution. That case is likely to resolve by that time and has the potential even to resolve via a civil compromise. And so hoping to have Your Honor not take action at this time on that. Further, with respect to the new DUI matter, it is out of Oregon. It has it's a third offense. Mr. Less is going to be very motivated to expeditiously resolve that matter, just for there to be any chance for that matter to not resolve as a third offense felony. And so hoping to resolve that case one way or another prior to Your Honor taking action on the this show cause motion.
What release conditions does he have in Oregon right now on that case?
Your Honor, I don't know. I don't represent him in that matter, so I don't know some of the details. To be candid, Your Honor, I do think he is needing to clear a warrant on it.
That is the city's understanding, and I'll be honest, it's been difficult to get things out of Wasco County. What we were able to find publicly this last week shows a current FTA warrant. So I don't believe there are any current conditions that have been set in Oregon because he has failed to appear.
So if I'm understanding correctly, Mr. Lusk enters a deferred prosecution in this court where he's not to consume alcohol, not to engage in any new criminal law violations. And again, I'm going to make sure I have my dates right here. So let me just look to make sure I have the entry date for the deferred prosecution correct. I definitely don't want to make any implications that are not right. So it looks like he enters his deferred prosecution in April of 2023. And then the next month in May of 2023, he gets an assault. And then he goes in July of 2023 and has an allegation of a DUI in Oregon. So within 3 months of entering this deferred prosecution, he's committed 2 new crimes, one of which I have at least the implication of alcohol is involved in. And he's on warrant status. So no, I'm not going to wait for these cases to be resolved. I think the position I'm in is why I just don't take Mr. Lusk into custody right now. I don't see clearly entering the deferred prosecution and then engaging in both criminal behavior and additional consumption. There's no, I mean, the threat to community safety is not someone drinking at home in their recliner watching TV. You're going out, Mr. Lusk, allegedly, and committing new crimes, both crimes against persons and driving related crimes. So no, we're not setting this out long term. I'm just at this point contemplating, I'm assuming if it's a felony warrant in Oregon, if I take Mr. Lusk into custody, they might expedite or extradite Mr. Lusk back to Oregon.
Your Honor, if I could be heard further, I mean, I would, if we're addressing the merits of the.
All right, before we get into what his attorney's going to say, I'm going to peace out. Let the video play. There's about 5 minutes left. So, if you haven't done it already, please like and subscribe to your Jump Kick Backflips. You know what to do. And if you would like to donate, Linktree is down in the description. But until next time, bye.
This is distinct and different from, say, a stay of proceedings where it's a condition of the stay of proceedings that even probable cause is sufficient to revoke. The condition here is that he not commit any new similars, so that's commit. I would argue that the simple charge is not sufficient to go forward.
On a deferred prosecution, Mr. Johnson, I'm on a preponderance standard to revoke. I don't have to be beyond a reasonable doubt. I have to be 51% certain that your client has been consuming alcohol during the time of his deferred prosecution.
And on that note, I think there would be a requirement for a lower evidentiary standard, but more firsthand direct primary evidence would be required. We don't have police reports. We don't know the facts. Your Honor doesn't have.
I'm fine with setting this out a week. I'm just not, I just can't understand how I'm letting him walk out the door today.
Well, and I think Your Honor has, with this is a pre-conviction, the status of the matter is as pre-conviction, so it's still a pending criminal matter. I think Your Honor does have discretion and authority to order conditions of release. I think we could, place him on scram. I think his plan, one proposal here would be set it over perhaps one single week, and within that week, he would take action to clear his warrant. In the meantime, Your Honor has discretion from our perspective to place him on pretrial release scram monitoring. He has an excellent track record of success while being on scram monitoring. I think that would be, an easier, simpler process than having to go through, a transfer extradition process. And so I think that's within Your Honor's discretion, and also takes into account the fact that, again, these are simply allegations at this point in time.
He self-reported a relapse though, just last month. He's still, even after he's on release in Oregon, he's still drinking. I'm looking at the information from Lifeline right here.
And Your Honor, because.
No, put your hand down.
Because defense has correctly noted, we are, if Your Honor's doing what the city is requesting and revoking deferred, we are back in a pre-conviction, pre-trial status. So any and all remedies are available to this court. We would let the court know the only reason the city found out about this was through essentially a phone call tip where we were specifically told that lives were put in jeopardy by this behavior. So we do think it would be appropriate, if you're setting over sentencing, that he be taken into custody and held until next Thursday.
The question I have, and I know that Wasco County has not been a place that has been readily available. How long has he been on warrant status?
I don't know that answer. I don't know.
You don't know how long you've been on warrant status?
No,
You don't know when your court date was supposed to be?
I never got a ticket up, Your Honor. I called him the other day.
So this happened in July and you've never gone to court there?
No, sir. They kicked me out of the hospital. I had no ticket, no nothing. I've never got anything in the mail. When I came in here and talked to her, last 3 months ago was the first thing I heard about this.
So you knew 3 months ago?
3 months ago, yes.
Then why haven't you done anything?
I will turn myself in
No,
tomorrow.
no. You've been still drinking, and you showed up in this court at least twice with a pending charge that you knew about for 3 months. You just told me that. So no, you're not dealing with it.
I can't afford a lawyer, sir. I got one here. I'll go there myself.
No, you're not stopping drinking. The only way for me to ensure that you stop drinking is you're going to go into custody today. I'm going to impose bail in the amount of $25,000, and I'm going to set this matter over to next week. I'm going to get the police reports, and we're going to have the hearing next week.
Anything else to address on that matter, Your Honor?
I think the only thing that we're going to do, so let me hang tight just a sec because I got to fill out the form here.